In mid-March of 2016, the FASB issued ASU 2016-06 on contingent put and call options in debt instruments, a consensus of the EITF. My name is Todd Raven, and I'm joined by Brian Perdwicki, and we are both senior managers in DPP. So before we get into the issue, let's briefly talk about the background of embedded derivatives. Brian, can you give us a little information to make sure we all understand?
Sure. Instruments that contain embedded derivatives must be assessed to determine whether those embedded derivatives need to be accounted for separately from the host contract. By embedding a derivative instrument in another type of contract, referred to as the host contract, the cash flows of the host contract, which otherwise would be required, excluding the embedded derivative, can be modified because of changes in the derivative instrument. Said another way, an embedded derivative is a derivative within another contract that is not a derivative.
Thanks. So 815, or formerly FAS 133, requires that embedded derivatives be separated from the host and accounted for as a derivative if three criteria are met. Today we're going to discuss one of the three. Under 815, if the economic characteristics and risks of the embedded derivative instrument are not clearly and closely related to the economic characteristics and risks of the host contract, an entity is required to bifurcate.
Just to add to that, ASC 815 also states that call and put options that can accelerate the repayment of principal on a debt instrument are considered to be clearly and closely related to the debt instrument unless both of the following exists. 1. The debt involves a substantial premium or discount, and the call or put option is only contingently exercisable.
Good point. So for contingently exercisable call or put options to be considered clearly and closely related, they can be indexed only to interest rates or credit risk, not some extraneous event or factor.
That's correct, Todd. Based on the guidance, many people had questions about when put and call options would be considered clearly related to the debt host. As a result, the Derivatives Implementation Group, or DIG, issued B16 and a four-step decision sequence to determine this. This was later codified in paragraph 25-42 of ASC 815. Maybe you can walk us through the four steps, Todd?
Yeah, so the four-step decision sequence works as follows. In step 1, you'd look at, is the amount paid upon settlement adjusted based on changes in an index? If yes, you continue to step 2. If no, you continue to step 3. Under step 2, you'd look at, is the payoff indexed to an underlying other than interest rates or credit risk? If yes, then the embedded derivative is not clearly and closely related to the host contract. If no, you would need to look at step 3 and 4. Step 3, does the debt involve a substantial premium or discount? If yes, go to step 4. No, clearly and closely related. And under step 4, does a contingently exercisable call or put option accelerate the repayment of the contractual principal amount? If yes, not clearly and closely related.
As a result, two views emerged on how DIG issue B16 interacts with the original guidance. Some believed that the assessment of whether a put or call option is clearly and closely related to its debt host only require an analysis of the four-step decision sequence. Others believed that they must use the four-step decision sequence and also assess whether the contingency that allows for the exercise of the call or put is indexed only to interest rate or credit risk, not some extraneous event or factor.
So Brian, with those different views, there could be diversity in the accounting for similar instruments.
Exactly. So the staff proposed two alternatives. Alternative A was to clarify that step 1 requirement was in reference to the payoff only and evaluation of the contingency itself was not necessary. Alternative B, that would change step 1 to clarify that you evaluate the payoff and the contingency. This would be done by changing step 1 to the amount paid upon settlement adjusted based on changes in an index, or is the call or put option contingently exercisable? Todd, could you please walk us through an example to illustrate these two different alternatives?
Sure. So let's imagine a company issued a bond at par for $100. The bond contained a call option at $108 if the S&P 500 is greater than X. The question is, how would an entity evaluate whether this option should be bifurcated? Under alternative A, an entity would do as follows. Step 1, is the amount paid at settlement just adjusted based on changes in an index? No, it's fixed at 108. Or another way to say it is the amount paid is not adjusted for changes in the S&P 500. So next they would go to step 3. Is there a substantial premium or discount? No, it's less than 10% difference, so no further assessment is required. An entity would conclude that the option is clearly and closely related to the host instrument and would not be required to bifurcate. Under Alternative B, an entity would perform the same analysis over the payoff as in Step 1. The entity would then consider whether the contingency trigger, in this example, the S&P 500 being greater than X, is an extraneous event. In this case, it would be at B, and as a result, the entity would conclude that the option is not clearly and closely related to the debt host and would be required to bifurcate.
The EITF ultimately reached a consensus on Alternative A. Members of the task force did acknowledge that it could result in different accounting results for some instruments that are embedded versus if they were issued under separate contracts. However, some task force members noted that the four-step decision sequence limits these situations by requiring an evaluation of whether a substantial discount or premium exists. Alternative B had the potential to unduly increase costs and complexity in financial reporting, as it would require more instruments to be bifurcated than happens in practice today. Todd, please explain effective date and transition.
So entities would apply a modified retrospective transition approach. Early adoption as of the beginning of an annual period is allowed for annual and interim periods for which the entity's financial statements have not been issued. The ASU is effective for public business entities and certain not-for-profit entities beginning after December 15, 2016, in interim periods in that year. For all other entities, it is effective for fiscal years beginning after December 15, 2017, and interim periods in the following year.
In addition, an entity would be also required to disclose the nature of and reason for the change in accounting principle and a description of the prior period information that has been retrospectively adjusted. The disclosure would be made in the first interim and annual period following the change in accounting principle. In addition, for those instruments impacted, an entity would also have a one-time option to irrevocably elect to measure the debt instrument affected by the proposed amendments in its entirety at fair value, with changes in fair value recognized in earnings, assuming the instruments are eligible for the fair value option.
So can an entity that elected the fair value because they thought they had to bifurcate unelect this option?
No. The EITF did consider this option, but the election of fair value under ASC 825 is irrevocable, and they could not identify any reasons why unelecting would be allowed.
Thank you, Brian. So with that, on behalf of Brian and myself, I would like to thank you for listening.